All right, hi everyone. Welcome to our webinar today. My name is Jason Q. I'm the Senior Managing Attorney at the DC Bar Pro Bono Center for our Nonprofit and Small Business Legal Assistance Program. For those of us joining live on the webinar, you'll find the presentation slides already available for you to download under the handouts column or tab of your GoToWebinar client. Also, for those joining us live, you will find a questions field where you can type in questions during the presentation. I will keep an eye out for questions and pause periodically through the presentation to assess the questions and to answer them as we go along. So again, if you're joining us live, please feel free to type in your questions as we go along. I want this to be, as interactive as possible, and especially when it comes to new nonprofits and people who are kind of at the beginning of their nonprofit journey, it's really helpful for me to hear your questions and to kind of understand where your main concerns are and what concepts or definitions might not be immediately clear to folks who are new to this sector and to this field. So, hit me with the questions. I welcome them immensely. Again, my name is Jason Q. The topic of our webinar today is before you start understanding the benefits and limitations of 501c3 nonprofit organizations. A little bit of more table setting just before we get off the ground. I want to tell you about us at the DC Bar Pro Bono Center and specifically our nonprofit legal assistance program. We do a lot of things to support nonprofits in the DMV and beyond, especially when it comes to legal questions and legal issues. We host legal clinics and brief advice services to connect nonprofits with attorneys for low barrier assistance and education. That includes almost weekly office hours that we offer where you can talk to a lawyer about nonprofit legal issues for free for 20 minutes and a bunch of other clinics and events that we do throughout the year. We sponsor trainings, webinars, and podcasts on important real-world legal issues facing nonprofits, including our very popular Board Basics series, which is an orientation for folks who are new to serving on a nonprofit board of directors. That'll be relevant to the conversation that we'll be having today. We provide written resources and archive training sessions on our website, which is linked here, lawhelp.org/DC/NPSB for nonprofit small business, including an index of all of our legal resources that you can browse by topic, which you'll find right there on the homepage. And for organizations that are in the district and are serving low income or other marginalized communities in the District of Columbia, including startup organizations, we do match nonprofit organizations with pro bono legal counsel. So these are volunteer lawyers who can take you on as a pro bono client and assist you through a larger scale legal project. Pro bono attorneys can help with many different types of legal matters, including governance, IRS compliance, employment law, real estate matters, and nonprofit formation. Again, that's if you're a nonprofit that's in DC and serving the DC community, and also you need to have an initial board ready and a business plan. But once you have those pieces in place, we can match you with pro bono attorneys to help you through that formation process. So something to keep in the back of your mind as we're going through today's presentation. Speaking of, here is an outline for today's webinar. So we're going to just start with a little bit of background about nonprofits and the nonprofit sector. We're going to highlight the benefits of starting a 501c3 public charity, which will be the focus of our presentation. And then once we go through the benefits, we're going to go through considerations and limitations, important legal restrictions and rules around how 501c3s operate and what they can do. I think this will address a lot of the lingering concerns or questions that people are coming into the presentation with. And then we'll close out by talking about some alternatives to starting a 501c3 nonprofit. If the preceding section has spooked you or made you realize that you're not quite ready or that a C3 might not be the right form for you, we'll do a survey of some of those alternative options at the very end. All right, great. I'm looking at the questions tab to see if we have any questions right off the bat. I'm not seeing anything. Again, please keep them coming. All right, let's start with some background about nonprofits and the nonprofit sector. So the nonprofit sector is a really significant part of the US economy. There are over 1.5 million registered nonprofits, accounting for nearly 6.5% of the workforce, which makes it the third largest economic sector, and over 5.5% of domestic GDP. In DC and in the DMV region in particular, we are a strong nonprofit sector. 26% of DC residents work in the nonprofit sector here in DC, the highest percentage in the nation. Okay, so a really vital part of our local economies, of our local local employers, on top of all the critical services and programs and education and other functions that nonprofits perform. The focus of today's training, as I hinted at, is going to be on a specific type of nonprofit, which is a 501c3 public charity. Public charities can include arts, cultural, environmental, and humanitarian organizations. They can also include educational organizations, including schools and universities, but also things like camps and educational publications. They can include healthcare organizations. There are nonprofit hospitals, nonprofit nursing facilities, nonprofit long-term care facilities, nonprofit clinics, etc., human services organizations, and many, many others. Religious organizations can also operate as 501c3 public charities without formal application to or recognition by the IRS, but many choose to file and register as a 501c3 charity anyways to ensure that they have access to nonprofit benefits and to establish their legitimacy. So religious organizations, because of concerns around separation of church and state, can operate as a 501c3 tax-exempt entity without any sort of application with the IRS, and you will see that many do, but some want to be listed in the IRS database as a registered nonprofit. Some want to apply for grants or perform programs outside of just religious services, and to do that, they usually need to be registered. So a lot of religious organizations will register even if they don't strictly have to operate as a 501c3 tax-exempt entity. Public charities account for approximately 2/3 of all registered nonprofits. So I'm going to assume that most of the people here want to form a public charity. They want to do that social services work, that educational work, advocacy work. All of this is in the 501c3 public charity category. I will note that aside from C3s, there are over 30 other types of tax-exempt nonprofit organizations. You might have heard of some of them: C4s, C6s, C7s. These include things like business leagues, chambers of commerce, fraternal organizations, civic leagues. Special rules apply to these organizations. They do not have all the tax benefits that 501c3s have, and they will not be within the scope of today's session. I will also note that within the 501c3 category, there are some organizations that are deemed private foundations instead of being classified as public charities. These are organizations, I'm just going to really briefly sketch this out. These are organizations that receive more than 2/3 of their funding from a single individual, business, a trust, or a family trust, or another source. You can think of, the Bill and Melinda Gates Foundation, or the Wikipedia Foundation, or other sorts of foundations that are just funded by one company or one individual, or sometimes a very small group or a small family of major donors. Because these organizations are so tightly funded and controlled by a small group of people, the IRS regulates them more strictly, and there are more restrictions and there are fewer tax benefits. So private foundations are subject to stricter oversight, reporting, and operational requirements because they're not what we consider publicly supported organizations. Donors to these organizations can also not claim the full tax deduction when they donate. Some private foundations have their own programs and services. We call these operating private foundations, while others primarily just give money or grants to other nonprofits. So these are non-operating foundations. So again, the Bill and Melinda Gates Foundation does a lot of actual programs and does like amazing charitable work around the world. That's an operating foundation. Other foundations, are just big pots of money, usually with endowments that generate interest and returns, and they use that money to grant other nonprofits doing work that's compatible with their mission and their vision. You generally do not want to be classified as a private foundation unless absolutely necessary. So again, that's why I'm assuming most of the folks here today are interested in forming a 501c3 public charity that doesn't have all these private foundation restrictions. And to do that, you just have to ensure that at least 1/3 of your revenue comes from small individual donations, or from other nonprofit organizations, or from self-generated program-related income, and we'll talk kind of about what that means in a bit, or from government sources, so government grants or government contracts. These are all, sorts of public support, we call them. So those are the kinds of sources that will count towards the 1/3 threshold. As long as you clear the 1/3 threshold, you will be considered a public charity instead of a private foundation. All right. Let's talk about the main benefits and advantages of starting a 501c3 public charity. The first and sort of core benefit, I think, is that nonprofits are mission first. They are legally required to pursue their tax-exempt mission. Unlike for-profit corporations and other entity types, there's no legal imperative to generate revenue or satisfy your shareholders. That means that the staff of the organization, the board members, are generally very passionate, they're driven, they're aligned with the mission. And this really helps to, flesh out the identity of the organization and to make sure that everyone working with or supporting the organization is on the same page. Nonprofits should have like a mission statement that describes what they actually plan on doing in the world. You'll also often see things like a vision statement, which is sort of a higher level of generality about what the nonprofit envisions the world to be in sort of perfect circumstances. And you'll also hear of value statements, which are values and principles that the nonprofit, that form sort of the foundation of the nonprofit's work and its worldview. So you'll hear a lot of terms floating around, but we'll focus on the fact that in terms of the mission, the actual project of the nonprofit, its reason for existence, the work that it wants to do in the world, that has to be very explicit. And that's in fact the basis upon which the IRS will decide whether or not you qualify as a 501c3 public charity and get all the benefits that we'll talk about subsequently. Speaking of, let's talk about the second big benefit is that nonprofits, 501c3 public charities are limited liability entities. They have to be a corporation. It is possible to have nonprofits as an LLC, but there are a lot of limitations and restrictions when you choose that form, and it also makes things complicated at the state or district level to reap a lot of the tax exemptions and other benefits at the local level when you're an LLC. So the vast majority of nonprofits are corporations. So that means that they are freestanding legal entities which can do things like open bank accounts, own property, enter into contracts, employ individuals, etc. And they do that all in the nonprofit's own name. That means that the liabilities of the nonprofit are limited to the assets of the nonprofit and do not extend to the individual assets of the organization's founder or its directors, its officers, its employees, etc. So if your nonprofit is sued, for example, and the plaintiff wins a $10 million claim and your nonprofit, only has $1 million, that liability doesn't stretch down into the pockets of the individual members or leaders of the nonprofit. It's limited to the nonprofit itself. That should give everyone a little bit of security and breathe a sigh of relief when it comes to the potential liability of working with or starting a nonprofit. There are also additional statutory protections that exist for nonprofit volunteers, including volunteer directors and officers. And finally, it's not on the slide, but as a nonprofit, you can purchase insurance to provide further against liability, including directors and officers insurance and also general liability insurance. So nonprofits create a relatively safe platform to do your work, and there are a lot of statutory protections and other ways that you can protect yourself from liability when working with and through a nonprofit. A third big key benefit is that nonprofits are tax exempt. That means that they are generally exempt from paying sales, use, franchise, property, what we would think of as income tax for businesses. All these taxes that for-profit businesses have to pay, nonprofits are exempt from paying most of these taxes at the federal and also local, district or state level. That's a huge business advantage. It makes it easier for the nonprofit to do its work and advance its mission. Another unique benefit of 501c3 public charities is that donations to your organization are tax deductible for donors. That creates a unique and compelling financial incentive to donate to 501c3 public charities for individuals and businesses that itemize deductions on their tax returns. As you know, a lot of individual donors might choose standard deductions, so that's less of a compelling benefit for them. But for folks who do itemize, including a lot of more high value individuals or individuals with a lot of assets or businesses, that can be a really important driver of deciding who to donate to if you have a decision between a 501c3 public charity and another kind of entity that doesn't have that tax advantage. There are also a ton of dedicated funding sources to 501c3 public charities. They are often exclusively eligible for certain government grants, government contracts, grants from private foundations, grants from other charities, and corporate sponsorships, co-ventures, and partnerships. So a lot of unique financial benefits in that space. Even if it's not a direct financial benefit, sometimes 501c3s are given special advantages in the market. Maybe they get, a first opportunity to bid on a contract, etc. So there can be a lot of fundraising related and business related advantages to operating a C3. And then the final benefit that I'll sketch out here is what we call sort of the 501c3 brand. So for donors and the public at large, the C3 brand is strong. It's in the community. We've had it for many decades. And so people recognize this as a sort of seal of approval from the government. They expect a higher level of transparency and accountability because of the enhanced local and federal oversight that exists around nonprofits. And because of this trust and assurance, they're more likely to give or support a registered C3 organization rather than, an organization that's maybe more spontaneous or that's just been created, which has not gone through the steps of being formally registered as a C3. All right, so these 6 benefits are the main benefits that I think of when it comes to starting a C3 public charity. You're driven by your mission, you have limited liability, you have these great financial incentives and advantages, and then you get access to that 501c3 brand. I'm going to stop here, take a look at questions. Alrighty, we will move along. So we've sketched out the benefits of starting a C3. Let's talk about some key considerations or limitations for prospective C3 founders. The first consideration that I'll put out there is that we need to make sure we're avoiding duplication. And to do that, we would recommend, this is not strictly speaking a legal requirement, but we'll recommend that people do a needs assessment and an environmental scan before starting their 501c3 organization. As I said at top, there's over 1.5 million 501c3s in the US. They are all competing for funding, for personnel, especially nowadays when there are a lot of staffing shortages across the sector. They're competing for other resources. They're even competing for clients, for constituents. So duplicating something that a nonprofit is already doing in your community is going to put you at an immediate disadvantage. It doesn't really help the sector as a whole, and it's arguably much better to scale up an existing organization instead of coming down and competing with existing organizations to basically do the same work. So to make sure that we're not duplicating or creating redundancies, we want to make sure that folks are performing a needs assessment as a first step. So identifying and describing the community you plan on serving and the specific needs you plan on addressing. And then as a second step, we would recommend that folks do an environmental scan to understand the existing nonprofit landscape. What other organizations exist in your community that are perhaps doing similar or the same work? So you can use online databases like candid.org or Catalog of Philanthropy. You could just do Google searches for nonprofits in your area doing the issue or subject that you're trying to address. You can talk to existing or allied organizations. And a framework that we encourage folks to think about is completing versus competing. If a similar organization does exist, can you distinguish yourself or serve a different sort of niche or serve a different audience? Maybe it's a new geographic area, maybe it's a different kind of client population, maybe it's providing services or delivering services in a different way. There's always a way to distinguish yourself from existing organizations, and that's really important to start to sketch out right off the top as you're beginning. All right. And another big tip here is that existing nonprofit organizations can help you identify underserved client populations or other types of audiences. Related to the environmental scan, we also recommend that folks put together a business plan. So a business plan, should take in the reality that nonprofits are businesses. You're not a for-profit business, but you're still a business entity. And that means that we need a detailed plan to attract funders, partners, and board members. And kind of more practically, having a business plan set up will help with your 501c3 application down the line. Having a business plan will encourage and require you to articulate a financially sustainable model for your organization and to identify initial sources of funding or opportunities for self-generated earned income. Components of a business plan often include your mission statement, a description of your programs, your environmental scan, surveying the landscape and seeing if you have competitors or similar organizations. It'll identify leadership and personnel needs and also assets. So who's in your founding team, and then who do you need to flesh out that founding team? It'll include your financial model, financial projections, and potential sources of funding, and it'll contain a short and long-term growth plan. You can find a lot of resources on business planning through things like the Small Business Administration. Here in DC, we have a lot of local agencies that are incubators or provide technical assistance to small businesses. So, you know, if you're working with a for-profit business plan template or resource, just remember that nonprofits are a little bit different, especially when it comes to your financial model. It's not just going to be sell services, get money in return, although that can be an important component of it. You'll probably also need to think about potential sources of donations, potential sources of government grants, even identifying specific government grants in your business plan to say our goal is to get this kind of grant. That is really compelling and will get you off to a good start. Okay, those are our two sort of non-legal considerations: getting, you know, having your needs, doing your needs assessment, environmental scan, putting together your business plan. The rest of what I'm going to talk about are specific legal requirements or restrictions that apply to 501c3 public charities. The first big one is that if you want to start a C3 charity, you have to be comfortable with the concept of board oversight and with shared control. So because nonprofits are corporations and are collective enterprises by design, the board of directors is the body that votes to determine the direction and priority of the organization, not any individual founder or chief executive or other individual person. So you as the founder can play a critical role in bringing this nonprofit into the world, but almost immediately that control of the organization will be shared with your board of directors. In DC, as with most other jurisdictions, nonprofits have to have at least 3 members on their initial board of directors when they become operational. They also must have at least 3 corporate officers, and those are a chair or president, a treasurer, and a secretary who have specific leadership roles. And in most startup nonprofits, the directors are volunteers and the corporate officers are also volunteers. Usually it's the same people wearing both hats. So I'll show you this in a second in a chart, but you'll probably have a team of people. There'll be directors on the board, and then some or all of them will simultaneously also wear the hat of the president or the treasurer or the secretary or another officer role. That's just because when we start out, we have a small team. People have to perform multiple functions. As your organization grows and as your board grows, we can start to sort of spread those duties around a little bit more evenly. Board service is a pretty serious endeavor with legally enforceable responsibilities. We call those fiduciary duties to oversee the organization and to protect its financial resources. So it's not a light undertaking. So going back to your role as the founder, you often choose the initial board members to serve on the board, and you can exercise a significant amount of control. You know, you're probably the one articulating the mission. You're going to be playing a huge role in drafting the articles and the bylaws and the other paperwork of the organization. You can also often be hired by the board to be the initial staff of the organization. So the first executive director or CEO will often be the founder of the organization if they do want to perform that function. And you make a lot of other key organizational decisions. So it's not like you have no power, but nevertheless, founders do not have 100% control and can definitely be outvoted or even voted off the organization, especially as the board and the organization grows. So that's just a reality of nonprofit organizations that founders need to become comfortable with. And a lot of folks really want that tight control and decide that a nonprofit entity is not the right format for them, and they choose one of the alternative forms. All right. I'm going to give you some examples of what a startup team can look like. This first example is the smallest possible team. As I said, in DC, you need at least 3 directors in your starting board. So I have an example here where we have 3 people. Person A, who's also the founder, person B and person C. Person B and person C might be, you know, acquaintances or people in the founder's business network, or they might work in the sector that the nonprofit wants to work in. These are the people the founders recruited to join the initial board. So you'll see that all 3 of these people have a check mark under director. They're all directors on the board. They all vote on the board, and all of their votes are equal. All right, so when you're a director, you're one member of a multi-person body. Everyone has the same vote. Everyone performs the same function. On the second line there, each of these three people also have some officer positions. So the person A, the founder, might be the president and might eventually be the executive director of the organization. Now, right now, they don't have money to pay the executive director. We're assuming that the organization needs some time to get funding. So they're not officially an employee yet, but they might be getting ready to become the executive director down the line. Person B is going to be the treasurer, person C is going to be the secretary. So we see that they're wearing two hats. They're all directors, and then they also have a separate officer title. As the organization grows out, let's spin off like a slightly larger team now. Let's say this is a year down the road or some amount of time down the road. The organization's got enough funding to hire a paid executive director. So under sort of model A, person A, the founder, has dropped off the board. So they are no longer a director. Instead, they've grown out the board a little bit. Now we have person D and E. So we have a four-person board. They're voting, they're making decisions. Person A has been hired as the executive director. So we see them listed now as an employee and as an officer. That's because executive directors are always officers of your organization, along with being executive staff of the organization. So that one position itself wears two hats. And then we see other folks on the board assuming those other officer positions, president, treasurer, and secretary, because those three are the legally required minimum in DC. This final one is a slightly different approach here. So in this example, the founder has decided to stay on the board, and they do also want to continue serving as the president. So we see now they have a check mark under director again, and their officer title is president. We have another board member as the treasurer. We have another board member as the secretary. Person D is just on the board, but they don't have an officer role. So they just vote with the board and they participate, but they don't have one of these specialized officer jobs. And they've hired person E to serve as the executive director, and that's all they do. They're not a director, and being an executive director makes them an officer, but they don't have any other officer role. All right, so these are different ways that this nonprofit can grow, hire staff, and you see different ways that the founder can be involved throughout the life cycle of this organization. Now, you might be asking, why do we not have the founder serving as a director, the president, and the executive director all at the same time? That's because as a best practice, it is ideal that we don't have staff, especially executive staff, simultaneously serving on the board as a director. The reason for that is because the board's job is to hire, evaluate, supervise, and terminate the executive director and other executive staff. So we don't want the founder being their own boss, right? They shouldn't be on the body that it decides whether to hire them, decides whether to set their compensation, decides whether they're doing a good job, while actually doing the job. So the best practice is to, once you have the ability to hire staff, not have those staff people simultaneously sitting on your board. That's not a hard legal requirement. And a lot of organizations, when they start, you're very small, it's hard to find people to sit on your board. So, some organizations will perhaps initially, perhaps long-term, have the executive director also sitting on the board as the director of the board. In that situation, we just have to be really careful about managing conflicts of interest. Whenever the board is voting on something related to that person in their capacity as executive director, again, that might be evaluating them, deciding how much they should be paid, deciding whether they should be fired, just making budgetary decisions that might affect their compensation or other aspects of their job. These are conflicts of interest. They would have to make sure that that executive director is excluded from any board discussion or decision-making around those topics. It gets tricky, it's possible, but it does make things a little bit more complicated. That's why the best practice is to just not have that sort of person on the board in the first place, so that we're not having to manage those conflicts of interest every time they come up. So I'm getting a good audience question here. We're interested in finding ways to make board service an option for more individuals. Do you see any avenues to pay board members for their work? This is a discussion that a lot of folks are having, and that has really shifted, I think, during the pandemic, and I'm hearing it more and more. So the baseline here is that board service as a director is traditionally a volunteer role. And the vast majority of nonprofit directors serve in a volunteer capacity. It is legally possible to pay people to sit on the board. And I hear a lot of interest in doing this, particularly to make sure that there's more diversity on the board, to make sure that folks who with limited financial means and limited time get some compensation to make it more, to make board service more accessible and more reasonable, especially if we want to sort of have people who represent our client constituency or the community that we're in. So there is growing interest in doing this. The short answer is it's possible, it's legal. It does open a huge can of worms from a legal perspective. I'll list some of the considerations. If you start paying your directors, they have to become W-2 employees of your organization. So right off the bat, you are now an employer and you have to abide by employment laws. So even if you don't have an executive director, if you're paying your board directors, your organization's employing people, and that opens up all of these, employment law compliance, HR type considerations. Two, you can void a lot of the statutory protections that directors have against liability, because those statutory protections are based on assuming that they're a volunteer of the organization. So if they're being paid, they're no longer strictly volunteers, and that means that a lot of that statutory protection from liability falls away. Again, you can purchase insurance and do other things to kind of buy back some of that protection, but a lot of those protections go away. C, it's sort of just a reputational issue because it's so unusual for directors to be paid. It just makes you stick out as a nonprofit. So when you're reporting your activities to the IRS, when you're applying for grants, when you're applying for contracts, when donors are looking at your annual paperwork and deciding whether they want to donate for you, a lot of experienced folks in the sector, a red flag will go up if they see that you're paying folks on the board. And so that might cause questions or complications or friction when it comes to fundraising. And I'll go on and on. I think I have an article floating around our resource index, which you can find on our website, listing, I think, 7 problems or concerns that come up when you start paying directors on the board. So I'll leave it at that. It is possible to pay directors on the board. It's very, very rare, and it creates a lot of complicated considerations that you probably want to talk to an attorney about. I will say that one kind of compromise or middle option is not pay folks for being on the board, right? Just sitting there as a director. But if you have directors who are performing special services to the organization, maybe they're sort of providing a special kind of insight or something that not every director can contribute, something unique. Maybe we can pull that out as a sort of consulting or a contractor type relationship that person has, and then we can pay them separately for those sort of consulting services. And so that's something that we can talk about. I don't want people to just jump into that option, but there are some options between paying everyone and not paying anyone. I'll leave it at that. A follow-up question here is, why would they be W-2 instead of 1099 employees? They have to be W-2 employees because a director of a nonprofit is a critical leader of the organization. They are legally responsible for running the organization, for all the organization's major decisions. And under the Department of Labor rules and IRS rules, that kind of person who's so deeply ingrained in the day-to-day work of the nonprofit cannot be paid as a 1099 independent contractor. A 1099 independent contractor is, your web designer, like a plumber, a person who just drops in and does a project, and that can include something like a consultant, but they're people who are on the periphery of your organization. They perform a service that you need, but is not critical to the work of the organization. An executive director or a director of the board, these people are the center of your organization. So they cannot be paid as 1099 contractors. They must be paid as W-2 employees if you do decide to employ them. All right. Continuing on with this theme of board oversight and shared control, another complication with having a board is that boards are complicated. There are a lot of personalities. There can be a lot of spirited discussion, disagreement, personalities, egos. So that's just something that folks should be prepared to manage and to deal with in the course of running their nonprofit. On the other hand, it's not all bad. Good board members can perform a lot of vital functions and bring critical expertise to your organization and resources. That can be financial resources. A lot of directors donate money directly to the nonprofit. A lot of them bring in-kind resources like legal expertise, accounting expertise. I've heard of folks bringing in the IT services and all sorts of great things. So, the board is very, very useful. You just have to recruit and retain those sort of high value board members. Especially for a startup organization, a lot of this is going to be critical for getting you off the ground, having people to share the workload and to bring in these different expertise that you don't have. Again, board service is almost always a volunteer capacity, so that can make board recruitment a little bit more challenging for a new sort of untested nonprofit. Big considerations here are finding board members with the bandwidth to serve as a director that have the needed skills and background. And then here's another important thing to think about. We ideally want at least 50% of the people on your board to not have family or business relationships with other members of the board or with the organization as, a contractor or a vendor or anything like that. We call these folks independent directors. They're serving there because they believe in the mission and they don't have any sort of family relationships with people involved, and they don't have business relationships with the nonprofit or with businesses of other people involved. They're independent. The IRS will ask you how many independent directors you have down the road. And as a practical matter, we want a healthy number of independent directors on the board because it makes decision making easier. If a decision involves someone on the board and they have a bunch of family on the board, under our conflict of interest analysis, which we'll talk about down the road, none of those people, the person and their family, can participate in the discussion. If everyone on the board is related to each other, then there could be situations where you just can't make the decision because there aren't enough disinterested independent people on the board to vote and to discuss and to make the decision. So that's why, as a best practice, we want at least 50% of the board to be independent. That's something you should think about as you're out there recruiting your initial board. So the big takeaway here: only start a nonprofit if you're comfortable with the concept of shared control and the demands of board management. All right, the second big kind of legal consideration we want to think about here is that nonprofits, 501c3 public charities, have limits on what we call private benefit and private inurement. They are created and they exist solely to advance their mission and cannot be operated for private benefit. That is, to confer financial or other benefits to individuals outside of the nonprofit's taxes and charitable program or its charitable class. There are particularly strict restrictions on benefits that flow to managers or leaders of the organization. The IRS calls these insiders. So if financial or other benefits flow to people who are making decisions on behalf of the organization, or it's flowing to their families or to businesses affiliated with those individuals, this is something called private inurement, and nonprofits are strictly not allowed to engage in private inurement. All right, so now I'm preempting a question that I get a lot. You can certainly pay individuals a reasonable rate to provide labor, goods, or services that the nonprofit needs to operate, including hiring staff and contractors, without it being classified as private benefit or private inurement. Everyone recognizes that nonprofits are businesses. They buy stuff, they need stuff, they pay people, and that is a benefit that we're giving to people. But it's because in return, we're getting business critical and mission critical labor, goods, or services. What you can't do is, A, you can't pay your insiders for labor, goods, and services that you don't need in the first place. You can't overpay your insiders, that is, pay at an unreasonably high rate for labor, goods, and services, even if you do need those things. And you can't have insiders influence or approve decisions to use themselves or their affiliates to provide labor, goods, or services, regardless of the rate. That is a conflict of interest. So all nonprofits need to have a conflict of interest policy and a process for making sure that when they're making decisions, people are not wearing their nonprofit hat and making a decision that then benefits them either directly or their family or their businesses by, let's say, having the nonprofit hire them or hire their company to provide some service as a vendor. They need to remove themselves from that decision-making process in order to not violate the conflict of interest policies. Another sort of consideration in this world of private benefit and private inurement is that the mission itself or the charitable class that you serve must be broad enough to constitute a public purpose versus a private purpose. So some guardrails here is that you can't form a nonprofit that right off the bat is locked into buying goods or services from a specific for-profit entity, or that generates business for for-profits, that advertises for for-profits or otherwise benefits a predetermined for-profit or private entity. So an example here, it's okay to create an educational nonprofit that teaches kids about animals using books, okay? But we can't create a nonprofit that will only use XYZ publishing brand books because maybe that publishing company is sponsoring the nonprofit or is sort of the entity that's kind of undergirding the nonprofit. So, you know, it's okay to create a nonprofit that offers counseling services that for free or for greatly reduced costs to folks who need it, but not okay for it to be required that all of those services be provided at cost from a specific counseling practice, you know? In that latter example, a business model where the financial or other benefits flow solely from a for-profit to a nonprofit, so that the benefits are flowing the other way, that's a much smaller concern, but we still want to talk to an attorney beforehand because there might still be some reputational or advertising type benefits that sponsoring for-profit could receive that we want to be concerned about. So I would advise folks to just not create nonprofits that, you know, in writing your articles or writing your mission statement, you're bound to use a certain vendor, a certain provider, a certain company, because that is going to tip off the IRS that this might be a private benefit violation. Another guardrail here is that you can't form a nonprofit to advance the interests of an overly narrow group of individuals or stakeholders. And there's no bright line here, but we have cases where some people try to form a nonprofit to improve the streetscape of a single city block. And the nonprofit was like, you know, that really looks like you guys just trying to increase your property values in that specific city block. A lot of the benefits are going into people's yards and other private places. There's not enough of a public benefit here to justify being a nonprofit. We've heard of nonprofits which are supposed to be scholarship funds for people from a certain family lineage. You know, that's going to cause problems. A nonprofit that only exists to benefit employees of a certain company. So the IRS doesn't want nonprofits that serve a finite kind of identifiable group of people. They want your charitable class to be broad and indefinite, in that we're not exactly sure who all the qualifying people might be, but we'll create sort of eligibility criteria and see who comes through the door. That's the preferred approach. Okay, a second sort of operational limitation here, and really relevant for folks, is that nonprofits do have some limits on earned income. Now, I want to sort of set the stage by saying that nonprofits can generate their own revenue and become financially self-sustaining, either totally or to some degree, and many, many do. There are, again, nonprofit universities and health clinics that charge fees for their services or that bill insurance companies, just like a for-profit hospital would, for their services. Many universities are nonprofit, but they still charge tuition and make money off of students and in other ways. All sorts of creative institutions, theaters, galleries, museums. You know, you go to the Met or something, you know, you have to pay an entrance fee. That's a nonprofit making money. And educational publications, publishing houses, thrift stores. We have things like Girl Scout cookies. There are a ton of different ways that nonprofits make their own money instead of relying exclusively on donations or grants or government contracts. In fact, this is a chart from 2016 data showing that across the broader nonprofit sector, almost 50% of the money earned is fees for services, basically nonprofits charging for some sort of fee or service similar to a for-profit entity might do. And then another huge chunk is from government grants or contracts, where again, nonprofits might be providing some sort of service in exchange for money. And that a relatively small amount of money is actually coming from individuals, foundations, bequest corporations, and other kinds of giving that we would associate with charities. Now, this doesn't apply to, I think, a lot of the folks listening to this presentation, because startup nonprofits are much more reliant on individual donations. You're just not big enough to get those big government grants or contracts, and it takes time to build up a fee-for-service model that's really bringing in a lot of money. So this chart is a little bit misleading for folks in the startup world, but I just wanted to show you that there's nothing unusual about generating your own income in the nonprofit sector. And in fact, a lot of nonprofit organizations have that as a business model. So don't discount that as either a component of your business model or potentially the large majority of your business model. Now, having said all that, there are limits on your ability to generate your own income. There are no limits on earned income if it's substantially related to the organization's mission. So that means that the income generating activity must be causally related to your exempt purpose. Just the fact that it generates money that you can then use for your charitable mission is not sufficient. The revenue rate generating activity itself must be related to the organization's mission. An interesting example that I'll use is, I think a lot of people know about NPR. NPR is a charity. It's a 501c3. It's a radio network, and NPR advertises. Some of the money comes from sponsors, and you'll hear at the beginning of many NPR shows a short little sponsor ad, and NPR is paid for those ads, and NPR makes money from those ads, and then uses that money to fund its programming and journalism, etc. However, that advertising revenue is not related to the organization's mission, because NPR's mission is not to advertise companies, right? NPR's mission is to do all the other stuff. So that is not a substantially related income. It's a very fact-specific analysis. If an activity is not substantially related, like that advertising example that I just gave, the income is taxed at the corporate tax rate. And it's something we call unrelated business income tax. So unlike other sources of income that you might have, like donations, grants, contracts, or revenue that you generate that's substantially related to your mission, all of that income is tax exempt. That business income, the stuff that's not related to your mission, that is taxable income. And so you have to sort of split your income into two streams. You have your taxable stuff and you have your non-taxable stuff, and you have to pay taxes on it. And furthermore, nonprofits that perform too much unrelated business activity can actually lose their nonprofit status. There's no hard limit on what too much unrelated business income is, but about 20% is rule of thumb. I'll give you another example that I find clarifying for people. If you walk into, so let's say we're going to a zoo that's a nonprofit, like here in DC, the Smithsonian is a nonprofit-esque entity. If we go into the gift shop of that zoo and we buy like a DC tote bag, and the zoo makes money on that sale, that money is not related to the organization's mission, because the zoo's mission is to educate people about animals and to keep animals, etc. It has nothing to do with selling tote bags. So the zoo would have to pay unrelated business income tax on the money it makes from that tote bag, and it can't generate too much of its money by selling tote bags and engaging in other kinds of commercial activity. On the other hand, if the zoo is selling educational, let's say, books on the animals in the zoo, that might be related enough to its educational mission that that income could be classified as program-related income, and the zoo can sell those books on a tax-exempt basis. So we have like one store, but even in that store, we might have different kinds of income depending on whether the sales, the economic activity is related to the program versus unrelated to the program. We have a webinar that dives a lot deeper into this, so I don't want to belabor it too much. The takeaway here for folks just sort of strategizing and at the founding stage is that if you would like to generate a significant amount of revenue from earned income, a nonprofit might not be the right choice for you, depending on whether the revenue generating activity can be classified as program related versus an unrelated business. We want as much of it as possible, ideally all of it, to be classified as program related, and we want to do as little unrelated business activity as possible. If you do want to generate a significant amount of non-related income, you may want to consider a for-profit social enterprise instead. So either a for-profit entity that can do some social good on the side, or some hybrid model, but a pure nonprofit might not be the right choice for you if you want to generate a significant amount of non-program related business income. All right, so a big flag for folks thinking about a nonprofit. Let's get to a few more key core limitations. There's a limitation on political activity. So 501c3 public charities are subject to limits on the amount of political activity they can engage in. And let me sketch out three kinds of activity that I'm talking about. Nonprofits can engage in an unlimited amount of issue advocacy. So this is advocating on public policy issues. This is educating the public or policymakers on issues of concern, so long as it doesn't qualify as either of the two other categories, which are lobbying or political intervention. So let me define those. Nonprofits can engage in a limited amount of lobbying. So not zero, but not too much. And lobbying here is defined as attempts to influence actual pending legislation. So lobbying can be direct, that's communicating with government officials or lawmakers or their employees to influence the passage of legislation, or it could be grassroots. It could be encouraging the public to take actions in order to pass or oppose pending legislation. Advocacy that does not mention specific legislation is not lobbying. So an example is, let's say you're an environmental nonprofit and you care about climate change and you care about carbon emissions. If you say we need laws that restrict carbon emissions from automotive vehicles, and you even go to lawmakers, you go to Congress, or you talk to folks in DC Council, and you say here are some ideas for laws that could reduce carbon emissions. Here's why carbon emissions are a big problem, and you're educating, you're advocating. All of that stuff is in the green category. It's issue advocacy. You can do as much of it as you want. Don't worry about it. But if a lawmaker picks up your idea and proposes a specific bill to, let's say, change the regulation of carbon emissions from automobiles, and then you start going around telling lawmakers, hey, please pass HR 162 or oppose HR 162, or you start to do advocacy around that actual piece of legislation, that's when it becomes lobbying. And again, nonprofits can do a small amount of lobbying, but it cannot be a substantial part of your activities. Under one common IRS test, only up to around 20% of your expenditures can go towards that kind of lobbying activity. So if your nonprofit, if your proposed nonprofit needs to engage in more than about 20% of your expenditures on lobbying, a 501c3 public charity might not be the right model for you. But a lot of organizations find that they can do a ton of issue advocacy and a pretty, impactful amount of lobbying while staying within the rules that govern 501c3 public charities. So we'd want to have a deeper conversation about what's possible there. Now, with all that said, there's a blanket prohibition on political intervention for 501c3 charities, which is defined as intervening in or participating in any political campaign on behalf of or in opposition to any candidate for public office. And that includes, just in sort of our current political climate, any sort of partisan, activities that, are associated with like political parties or spectrums, just because it's very easy to connect those activities with specific candidates for elections. All right, so if you want to start a C3, just zero political intervention whatsoever. If you would like to engage in any political intervention or more than an insubstantial amount of lobbying, then a 501c3 might not be the best entity's choice for you. There are things like C4s, C6s, PACs that can do more of this kind of activity, so you might want to explore those options instead. Okay, we're getting to the end of our sort of limitations and considerations. I just want to sketch out really quickly here another big consideration for founders, which is just that starting a 501c3 is complicated and it also costs money. All right, so incorporating a 501c3 is a multi-step process. Here's a very high level outline of what you need to get it off the ground. You need your initial board members, at least 3 in DC. You need to file articles of incorporation with a state or district agency. So in DC, you file the articles of incorporation online with DLCP, the Department of Licensing and Consumer Protection. It's $80. They'll turn it around in a couple of days. A note about your articles is that they must contain some IRS required language in them for you to be able to qualify for 501c3 status down the line with the IRS. So that's just something to keep in the back of your head. We have templates and all these resources to help you find that. But the sort of trap here is that if you just fill out the online form that the district agency provides you with, it will not automatically include the language that you're going to need down the road. So you want to be proactive about researching and adding in that additional language when you go to fill out the form. One decision to make at this stage is to decide if your nonprofit is going to be a membership or a non-membership organization. So we use the term membership here in a specific legal sense, where, a couple slides ago, we were talking about how you have the board and your officers and your employees. In a membership organization, there's a fourth category of people called members who have voting rights to approve major corporate decisions and who usually also elect directors onto the board. In a non-membership organization, the directors themselves elect new members onto the board. So there's just kind of a cycle and people cycle on and off, and the board kind of elects new members onto itself. And the board has final say in making major corporate decisions. In a membership organization, we have to sort of triangulate that around a group of people called members who are not full board members, but who have some voting rights and also the ability to appoint board. We're not talking about membership organization in the sense that you have what I call small m members. These might be donors, they might be people in your program, they might be people in your professional association or whatever. That is not the kind of member that we're talking about here. We're talking about a legal definition and a definition of who has sort of voting rights and control over your organization. The vast majority of nonprofits are non-membership organizations, where it's just the board and the officers and the executive staff making the key decisions. There is no group of members kind of inserting themselves in that process. Some organizations, especially depending on kind of how they're structured and what they do, it might make sense to have members. Most of them don't, and it is more complicated to run a membership organization. All right, continuing our sort of sketch, you'll have to draft bylaws, which sort of spell out the internal operating rules of your organization. You have to draft a conflict of interest policy and other policies. I won't get too deep into that. You have to have an inaugural board meeting. You have to get, and then finally get your federal recognition from the IRS, which is filing Form 1023. There are two versions of Form 1023. There's a streamlined version for smaller organizations that don't expect to exceed $50,000 in their first 3 years of existence. And then there's a larger kind of full form for organizations that expect to be larger than the easy filers, which is a much more complicated form. It's more expensive. And so you're going to need to decide at that point which form you're going to file. A sort of another practice note here is that no matter which form you file, you're automatically going to be considered a private foundation unless you opt into being classified as a public charity. So that's just a trap that I've seen a lot of people fall under. And then processing times for 1023s vary significantly. I've started to see EZs get turned down very quickly in like 3 weeks, although usually it takes a month or two. The full form can take 6 months, sometimes longer, sometimes shorter, but the full form is also takes a lot longer to get processed. All right, and then once you get your 501c3 status from the IRS, then you have to go back to the DC government and apply for tax exemptions and your basic business license. Not going to go into that too deeply. And then finally, there's also something called charitable solicitation licenses. So in many other states where you want to do fundraising, you also have to get licenses in those states. I sketch all this out not because this is meant to be an in-depth explanation. We have other resources to help you navigate all this. I just wanted to show that there are a lot of steps involved, a lot of filing fees, a lot of forms to file. So just be ready for that part of the process. And then my last point on this is that there are then ongoing governance and administrative requirements to keep your nonprofit up and running and in compliance with IRS rules and with local laws governing nonprofits, including annual financial reports to the IRS. Some people call this a tax return. That's not really the right word for it because you don't pay taxes, but it's the Form 990, which is an information return that you file at the IRS. There's 3 versions of it that you file depending on your size. Then at the local level, the district requires you to file a form every 2 years to maintain your corporate status. You have to keep your board up. You have to keep it meeting. You have to make sure that everyone is overseeing the operations and finances of the nonprofit, things like strategic planning and keeping minutes. You have to always avoid private inurement and conflicts of interest. So we've sort of touched on that already. There are record-keeping requirements. There are donation acknowledgement requirements. And then there are your sort of day-to-day business operations, right? Like any business, if you have employees, you have to comply with employment law. You have to think about risk management insurance. You have to think about accounting, bookkeeping, financial management, audits once you get big enough, and plenty more. So, again, this is not the webinar to get super deep into all this stuff, but I did want to flag for people that eventually you'll be running a full-fledged business, and you need to make sure that your founding team has the capacity to grow and to oversee the growth of these business functions. A lot of founders are really committed to the mission, and they might be subject matter experts in affordable housing or in domestic violence assistance, or whatever. You might be really passionate and experienced in that area, but do you have the bandwidth in your team for these other administrative and business related needs? I'm going to spend 1 minute going through these alternatives to starting a nonprofit, and then I know we're over time, but I'll go back to audience questions just for people who are able to stay on or who want to listen to the recording. They can get into those audience Q&As in a second. Okay, so let's talk about opportunities within existing nonprofits. If all of this has spooked you, just know that one sort of alternative path is to seek out existing nonprofit organizations that can house your program. Still do sort of a soft business plan, identify sources of funding, make an argument for why it fits within that organization. And that is, a good alternative to starting a new organization from scratch, because you'll have the board there, the legal entity is already there. You just have to sort of plug yourself in. There's also another compelling alternative called a fiscal sponsorship, where an existing 501c3 organization provides support to charitable groups or initiatives that don't yet have their own 501c3 status. So this can be used as like an interim option, or it can be used as a sort of way to pilot your program. But essentially, you find an existing organization that's interested in taking you on as a program, almost like a department under their existing entity. They'll provide some back office support. And then down the road, if you do form your own 501c3, you can then spin it out of the sort of incubator that you've been using through your fiscal sponsor. If you do, this can be a really good model for like incubation stage projects, time limited projects that don't need to exist forever. So if you just want like a one-time campaign or a short-term project, it might make more sense to do a fiscal sponsorship than to create your own nonprofit that lasts forever. A lot of emergency disaster relief kind of projects, you just don't have time to create a new 501c3, so a fiscal sponsorship works great. A lot of things like coalitions or consortiums or collaborations, where everyone already has their own C3, it might not make sense to create a new one just to house the umbrella organizations. So you might just house that as a fiscally sponsored project within one of the existing members of the coalition. International projects can often be fiscally sponsored by US entities, and that can help them have a presence or a footprint in the US without having to form a full C3 organization, although we'll need to talk a little bit about some governance concerns if you do go down that road. And then just individual or small scale enterprises, like a lot of support for individual filmmakers or artists or ad hoc activist groups. It might make more sense to house that in an existing 501c3 through a fiscal sponsorship model than it is to spin off into a brand new organization. For projects, you get to receive tax deductible donations without having to create your own 501c3. Instead, those donations are processed through the existing C3 and then kind of granted to you or dispersed to you for use. The sponsor can provide additional back office support, and it creates room for growth. For sponsors, it's an opportunity to advance the mission of an allied organization, which can then subsequently advance their own mission or their own vision for the sector and for the work that they're trying to do. And here, the last point is significant. It's very common for sponsors to charge an administrative fee, so maybe like 5% or 10% off of any money that comes in for the project, the sponsor will keep as a fee for offering the sponsorship services. So that's a way to make it financially sustainable for sponsors as well. Okay, so if you do go down this road, major considerations: make sure that the sponsor and the project are aligned in terms of their mission. Make sure that there's something called variance power in your fiscal sponsorship agreement. Because your sponsor has 501c3 status, it can't just be a passive conduit that takes money and immediately gives it to you. At every step, it has to be independently assessing, are they going to use the money correctly? Are there any red flags with how they've used the money in the past? And there have to be some controls to make sure that your project, even though it doesn't have C3 status, it's not spending or using the money in a way that would violate nonprofit laws. There's a lot of financial and programmatic oversight that the project should be exercising over that the sponsor should be exercising over the project. And finally, we'd want to see a written fiscal sponsorship agreement just to memorialize all of these considerations and to kind of prevent conflict or misunderstandings down the road. All right, so fiscal sponsorships, very viable option. We have a webinar linked a few slides ago where you can dive in and learn a bit more about it, but a good interim option for a lot of groups if you're not immediately ready to start a C3. Or another common situation is that you already have funding identified and like ready to go, but your funder or the granting agency says, we only want to give this money to a C3. And you are in the process of forming one, or you haven't started yet, but you want the money, that might be a good time to find a fiscal sponsor to accept that donation and then hold it and disperse it for you to use while you're getting your C3 off the ground. A third alternative to starting 501c3 nonprofit is to start a social enterprise. So these are organizations that address a basic unmet need or solve a social problem using a market-driven approach. It could be things like give back programs, kind of businesses that have very transformative business practices, or businesses where the products or services themselves have a social impact. But at the end of the day, there's a for-profit business involved in the equation. We're either purely a for-profit business or we are a hybrid entity, but you're not just relying on a 501c3 nonprofit to do the work. there can be some social enterprises that have a C3 involved, but many others are formed as either a traditional for-profit entity, or there are some new for-profit entity types like 3LCs and benefit corporations or B Corps that have been created just for the purpose of making money through a market-driven approach, but also having a kind of social impact viewpoint or commitment undergirding the business. Like there could be a lot of advantages to creating a non-C3 social enterprise. There's no limitations on revenue generation. So that whole conversation we had around unrelated business unrelated business income tax doesn't apply if you're a for-profit business without that consideration. You can avoid a lot of the nonprofit formalities. It's generally more straightforward to start a for-profit business and to maintain one than it is for a nonprofit. A really important consideration is that C3s cannot attract investors the same way that for-profit businesses can, because you can't pay dividends to investors out of a C3. So if you have investors that are expecting to reap a kind of return from your organization, that can only come in the form of a for-profit entity and not a C3. And there's just growing recognition of the social enterprise brand in society. So you can connect with people who are interested in supporting benefit corporations or other sorts of social enterprise projects. Social enterprises, again, can take a lot of different legal forms, including traditional LLCs or C Corps, but there are also things like a benefit corporation, which looks a lot like a traditional corporation, but is allowed to pursue a social mission. And then there's also L3Cs, which looks a lot like an LLC, a limited liability company, but they are also then required to fulfill a charitable purpose on top of operating their business. So there are some options here. And finally, we have the option of creating multi-entity structures like a nonprofit that owns and operates its own for-profit business, or a nonprofit that has like a sister for-profit business. We're not going to get into those formalities too much, but just know that there is some flexibility here and some other options available if a pure nonprofit isn't going to accomplish what you need to accomplish or can't operate the way you need it to. At the same time, having two different businesses at the same time, that's twice as much administrative burden, could be twice as much cost. So it's not a good option for everyone. And we would like to fit everything in one entity if we can, to the extent possible. All right. And I won't talk too much about B corporations right now. There's just another option to get a certified B corporation down the line. Instead, I'm going to use the bit of time that we have left to turn to audience questions, see if there's anything else that we can get off our plate. Thanks for everyone who stayed on overtime. Our organization has members in the US and abroad for joint research, education, and conferences. Does this present any barriers to forming a US nonprofit? That's a great question. US nonprofits are totally free to have a presence overseas, to operate abroad. You can structure that in different ways. You can be a US entity only, okay, and then have members in other countries. That is, in a lot of ways, the more straightforward way to operate. You would report to the IRS when you file your application, and then on an annual basis, who your overseas members are, how you engage with them, how financial benefits flow to those people. We're mostly concerned about money flowing out of the US into overseas entities or individuals and not being used in a 501c3 appropriate or legally compliant way. So if you do have overseas operations or you give money to overseas operations, the big consideration there that the IRS will want to see is a system for only pre-approving certain expenditures or certain programs that money can be used for on the front end, and then on the back end, having a reporting and audit system to make sure that the money is spent the way that you want it to be spent. But as long as you have some guardrails up there to make sure that the money is being spent appropriately overseas, there's no problem with having a US nonprofit that has an overseas presence or overseas programs. Let's see here. We approached a national organization about fiscal sponsorship and they worried about legal risks. There are certainly sponsor risks, and a lot of prospective sponsors will tell you that they're not interested in doing that or serving that function because they're just not equipped to handle the risks. The legal risks come from the fact that when you're a fiscal sponsor and you're sort of adopting a program or an initiative that's just getting started, if that program or initiative does anything that violates nonprofit laws, or indeed like injures someone or does anything that exposes it to liability, that will float up immediately to the sponsoring organization, because the sponsoring organization is the only kind of organization in the room. It's the only thing that's registered. It has a legal entity. It has 501c3 status. So all the liability, all the plaintiffs, when they're filing their lawsuits, they will aim for the sponsoring organization. So there is a lot of prospective liability there. That's why the sponsoring organizations need to make sure that they oversee how the projects spend the money. They have to make sure that there are guardrails. Like, for example, we mentioned that 501c3s cannot engage in political intervention for or against political candidates. When you have a fiscal sponsor situation, the sponsored project also cannot engage in political intervention. And if it does engage in political intervention, the sponsor's 501c3 status could be terminated. So that's probably what the sponsor was worried about in terms of legal risks. It is a serious undertaking to make sure that the sponsored projects are operating in a way that's consistent with 501c3 rules and regulations. All right, I'm not seeing other questions on the line. Thanks again for folks for your patience if you've stayed a little bit over the hour. We have here on this page a really great collection of nonprofit resources for startup organizations. We have our main nonprofit resource library there, lawhelp.org/dc/CED. And then we have a kind of microsite there with all of our starting a nonprofit resource collection. And I've also linked here our main written resource guide with links to template documents, etc., about starting a nonprofit in DC. So if after this presentation you still think that the nonprofit is the way you want to go, turn to these resources and they will help you get off to a good start. Also on our webpage, you'll find links to our brief advice services, office hours, and other ways that will support you during your nonprofit formation process. All right, take care, everyone, and we'll hope to see you at a future training or event. All right, bye.